Good afternoon. My name is Michael Otten. I represent an ongoing association of business and law school alumni called Reform Elections Now. Our group was inspired by a 2017 report in which Catherine Gale and Harvard Professor Michael Porter hypothesized that current U.S. election process is a cause of much of today's extreme polarization. They identified the resulting government paralysis as a major detriment to U.S. business competitiveness worldwide. Our small group is not made up of political scientists, but merely concerned citizens.
Al?
Can we mute some of the people that have come in late? Perhaps, Herb, you can check that.
Yeah, I'll do that. I'm going to mute.
Having said that,
Wait, Mike, I have to unmute you.
Michael, you're muted.
I think perhaps Herb was overzealous in his muting here. Okay, so I said our small group is not made up of political scientists, but merely concerned citizens. However, we are aware of our nation's basic principles and constitution and that they were built on a foundation of political philosophy from the 18th century. We've been motivated to look to current-day political scientists and legal scholars to review the options for some of today's elections issues, particularly the out-of-date laws of the 19th century, which provided a legal premise for much of the January 6th turmoil. This afternoon, we're privileged to have with us the foremost scholars who are dealing with U.S. electional law and democracy in the 21st century. Rick Pildas is an NYU constitutional law professor who was a recent member of the Presidential Commission to review potential reforms of the U.S. Supreme Court. He is one of the country's leading experts on legal issues concerning American democracy and government structure, including voting rights, elections, and campaigns, along with separation of powers and administrative law. Ned Foley is an Ohio State constitutional law professor and director for election law, founder of their Democracy Studies program, and author of Ballot Battles, The History of Disputed Elections in the United States. He has studied and written extensively about pros and cons of alternative voting systems. Professor Larry Diamond is a senior fellow at the Hoover Institution and the Freeman Spogli Institute for International Studies at Stanford University. He's an internationally respected expert on comparative democracy and has written extensively about democracy trends. From our own Reform Elections Now group, Director of Research Peter Cyrus, who spoke to many of today's audience in mid-2020 about scenarios based on our three professors' work, one scenario of which actually was a surprisingly accurate prediction for the disruption of January 6, 2021. He will introduce this evening's program, outlining some contextual history of the contested elections. Professor Pildes and Foley will then describe the current status of congressional action and explain the urgency to act now on rewriting some of the laws that are currently in place. Professor Diamond will finally comment on the implications for our democracy, with panel discussion and Q&A to follow. We do not seek donations, but we do expect concerned citizens to do their part to influence our elected congressional representatives, to have them pass vitally needed new laws this year in order to avoid a 2024 election debacle, a debacle worse than that of the 2020 cycle. Please keep your microphone muted to avoid background noise, but feel free to raise comments or questions in the Zoom chat window. Even better, join the conversation during the panel discussion by using the Zoom raise hand function. I now turn the meeting over to Peter Cyrus.
Thanks, Mike. Herb, can you pull up the presentation?
Absolutely.
Okay, so We have to fix election laws now to avoid a disaster in 2024. Next. Our messy and poorly written election laws in mid-2020, Ned Foley, who we will hear from later, wrote an article entitled "Preparing for a Disputed Presidential Election," in which he showed step by step what could go wrong in 2020. While Donald Trump and a majority of Republicans continue to think the election was stolen, we were actually very lucky because the laws governing U.S. elections are not well written, and we could have had a far more disputed election. If we had to avoid a much greater crisis in the future, we need to rewrite our election laws. Unfortunately, as Mike has said, we have a group of eminent scholars, including the three here tonight, who are working with a bipartisan group of senators to rewrite these laws before a more serious constitutional crisis occurs. But before we turn to the scholars, we would like to ask a few polling questions and then walk you through a scenario of things that could go wrong in 2024 if we don't act. And we get to polling questions, please answer quickly because we're going to move through them. Next. Okay, question number one. Who was the first vice president to take disputed electoral votes, enabling him to become president? Thomas Jefferson, Millard Fillmore, Martin Van Buren, or Chester A. Arthur? Herb? Okay, vote. Vote quick. We got smart people here. We got smart people. Okay. Let's close. Everybody's getting the answer. Let's close this poll and move on. Okay. End poll. Because Thomas Jefferson is the winner. And let's go back to the presentation. Okay, next. So as most of you guessed correctly, the winner was Thomas Jefferson. In 1800, Vice President Jefferson declared he had won the disputed electoral votes from Georgia. These votes provided the margin for Jefferson and Burr to defeat incumbent President John Adams. Now, in fairness to Jefferson, he and Burr almost certainly won Georgia, and there was no objection to his taking the votes. But the precedent exists. Now, fun electoral fact number one. Because of a loophole in the election laws relating to who would be president and vice president, Jefferson and Burr each received 73 electoral votes. Congress held 35 ballots to decide between the two. On the 36th ballot, Alexander Hamilton convinced a delegate from Delaware to switch from Burr to Jefferson. Jefferson was elected. Burr was pissed off. 3.5 years later, Burr, let's go back, I didn't finish. Burr killed Hamilton in a duel. We do not know if Donald Trump has purchased dueling pistols, but this is a great dueling pistol here. Next. Okay. The next question. Which of these people have not received electoral votes for president or vice president? Colin Powell, John Kasich, Lindsey Graham, Susan Collins, Face Spotted Eagle, Maria Cantwell, Elizabeth Warren, or Bernie Sanders. 7 of these people have received, 7 of these 8 have received votes for president or vice president. Let's get the poll up there, Herb.
To vote for or who didn't?
Which one did not?
Which one
Which
did
one
not?
of these people have not?
Which one? Only one did not. 7 of them
Only
did.
one.
You have to mute. The folks who are talking must mute.
Please mute.
Excuse me.
Okay, that's good enough votes. We'll give another 10 seconds.
Okay, I think we got it.
Okay. Well, sadly for you, Maria did get votes. The winner is, let's go back to the presentation and the poll, back to the presentation.
Okay. Peter, are you there?
Yeah, I don't see the presentation. I just see the poll.
We see the presentation.
Okay, there, I'm getting rid of the poll. The winner is Lindsey Graham. Now, electoral college delegates have often ignored election results and cast ballots for whomever they wanted. In 2016, Colin Powell got Democratic votes, 3 of them. Bernie Sanders, Face Spotted Eagle, and John Kasich all received electoral votes for president. And Elizabeth Warren, Cantwell, Collins, and others received votes from vice president for faithless electors. Now, what happens if between the day of the election and when the Electoral College meets, what happens if a candidate dies? Have anybody thought about that? It happened once in 1872, where Horace Greeley, the Democratic and Liberal Republican candidate, died on November 29th. And his electors voted for 17 different sets of candidates. Now, when the Washington Post asked Rick Pildas, who is our next speaker, what would happen if a candidate died before the Electoral College met, he replied, quote, "This is the messiest situation and could unleash a lot of different disputes." So just assume that the candidates next time are Trump and Biden. I'm not saying they should be or will be, but assume the candidate in the lead who has the most votes dies before the Electoral College meets. Who would be the next president? If you think you know, you're wrong, because the rules are all over the place. Now, what would happen if this occurred? How would the country respond? Well, I'm going to go back and use Rick's words. It would be messy. Now, these are just a few examples of what could go wrong, but there are many more potential holes in our laws. Next. Now, we're going to turn to a series of hypothetical events that could occur in 2024. For the purposes of this presentation, we're going to assume that the 2 major candidates are Biden and Trump, and that the votes on the state-by-state basis are the same as they were in 2020. We recognize that these might not be the candidates, and the vote will certainly be different, but using the same results makes it easier to address election issues. Next. Okay, in 2022, the Republicans have a strong showing. They win the Senate, they win the House, they capture governorships in Wisconsin and New Hampshire, and Purdue defeats Kemp in Georgia. Next. Now, in 2023, there are a couple of legislative changes. Arizona and Georgia vote to take election administration from the hands of the Secretary of State and place it in the hands of the state legislature. And Wisconsin and New Hampshire adopt the electoral vote system used in Maine and Nebraska, 2 votes for the state as a whole, 1 for each congressional district. Next. Now, election day comes, November 5th, 2024. Biden leads 80.4 million to 73.6 for Trump, and others, including, Andrew Yang or whoever, get 6.8 million. Biden leads in states with 303 electoral votes. However, because of the new systems in Wisconsin and New Hampshire, Trump gets 5 of those votes. So Biden's margin is 298 to 240. The Republicans win the majority of the Senate and the House seats. Next. So the state legislatures meet to appoint electors on December 12th through 14th. In Arizona and Georgia, the state legislatures invoking the Failed Election Act of 1845, some I know you guys focus on every day, claim that there has been fraudulent voting and cast their vote for the Trump state slate of electors. Republican governors in both states approved the decision of the state legislatures. In Pennsylvania and Michigan, the state legislatures approve a Trump slate. The Democratic governors approve a Biden slate. Next. On December 16th, the Electoral College meets. Trump gets 301 votes. Biden gets 237. Trump declares victory. I don't know why he doesn't have a bigger smile on his face. Can we go just back? You know, he should look happier, but I can't explain why he's not. Next. The Democrats file lawsuits claiming Biden won Georgia, Arizona, Pennsylvania, and Michigan as he received more popular votes in those states. They claim the laws in Georgia and Arizona giving the legislature the final authority are illegal. And they also claim that in Michigan and Pennsylvania, the slate supported by the governor should be accepted instead of those supported by the state legislatures. Next. So on December 21st, the Supreme Court refuses to rule on the legitimacy of the Arizona and Georgia slates, claiming that the election rules have been determined by the 12th and 20th Amendment. And it also refuses to rule on the selection of the two competing slates from Pennsylvania and Michigan. So the votes are sent to the President of the Senate, Kamala Harris. Next. So on January 6th at 1 p.m., Congress meets in a joint session under the 12th Amendment in the Electoral Account Act. Vice President Harris begins the count of the electoral votes. After Alabama, Alaska and Alabama, they do it in alphabetical order. Harris announces she will not open the ballots from Arizona. She says Biden won the state and the votes from the legislature and the governor are illegal. Objections are filed by the Republicans. Harris adjourns the meeting. Next. So the two houses meet separately. In the Senate at 4 o'clock. In the Senate, Harris declares votes from all states are illegal. She has followed the rules of the Electoral Account Act of 1887, and Biden is duly elected president. In the House, next. Since the joint session has not produced the victor in the Electoral College, Speaker Kevin McCarthy, who, got to be Speaker because he sucked up to Trump, invokes the 12th Amendment, which states, quote, if no person shall have a majority, then from the persons having the highest numbers, the House of Representatives shall choose immediately by ballot the president. The House votes to approve the electoral votes from Arizona, Michigan, Georgia, and Pennsylvania and declares Donald Trump as president. Democrats protest and file a lawsuit with the Supreme Court. Next. Well, the next day, riot erupts throughout the country. The Dow drops 13,000 points, 500 people are shot. Stock markets plunge around the world. Next. The Supreme Court meets to consider various arguments. Biden claims he won the popular and the electoral vote. Trump claims he won the electoral vote and that, quote, this is the greatest fraud in U.S. history. Next. On January 8th, riots continue. 700 more are shot. The stock market declines another 6,000 points. Russia attacks the remaining independent portion of Ukraine. China blockades Taiwan. President Biden invokes the National Emergencies Act. Next. Now, on January 9th, the Supreme Court rules. It could rule for Trump or even Biden or send the election back to Congress, instructing it to settle. In either case, the riots would likely continue and a large percentage of Americans would be left with the feeling that the 2024 election was a fraud. Now, we have presented one hypothetical scenario. There are other examples. For example, the Democrats could still control the House with Hakeem Jeffries as Speaker. But under the rules of the 12th Amendment, each state would have one vote and the Republicans would still be in the majority for the election of the president. Next. The point here is that our failed election laws, such as the Electoral Account Act of 1887, the failed election law of 1845, along with the 12th and the 20th Amendment, have issues that need to be addressed. Fortunately, as we've said earlier, there's a bipartisan group of senators that are working on a rewrite of these laws and a group of academic experts who we're really fortunate to have here today guiding them. So tonight, we have three of the leading scholars in the United States who will explain what steps are currently being taken and what we can do to help. As business leaders, we cannot afford to have a disputed election. We need to work to influence the senators to clean up these laws before it is too late. So now I'm going to turn the call over to my neighbor and NYU professor, Rick Pildas.
Well, first of all, thanks very much to you, Peter, and to Mike for your incredible commitment on these issues, your engagement on these issues. It's a real pleasure to be working with you on them. And also, I want to thank everybody who is on the Zoom call, taking time away from gorgeous places like the West Coast of Florida and various other places to participate in the discussion. So we really appreciate that. At the national level, the most important and politically plausible legislation that can help forestall a crisis over the 2024 presidential election is to clarify and modernize, update the 19th century statute that Peter referred to, the Electoral Account Act. This is the statute that regulates the election processes in the states and the relationship between Congress and the states and the Electoral College. And we need to update this act and to clarify it to create a much more stable and certain legal framework for the 2024 election, including how to resolve any disputes that might arise in the states or in Congress. And we will talk to you about some of the details for this reform effort, but I want to start by saying there's some good news on this front at this stage. As Peter mentioned, there's been a bipartisan group of about 16 senators that have been working on this reform effort for a while now. There's another group, a committee in the Senate, led by Angus King, Amy Klobuchar, and Dick Durbin, that have been also working very hard on reform in this area. And there's also significant bipartisan agreement on some of the major issues that need to be fixed. So that's good. Ned Foley and I have been working over the last, I think, 5 or 6 months with individual senators, individual members in the House and their staffs on this reform effort. And it's been a very substantive and good development so far that's been taking place. Now, the bad news, and this is something Mike alluded to, the bad news is without outside pressure, there's an increasing risk that the process is going to lose momentum. Members of Congress get no credit from voters for enacting reform of a statute like this. I mean, can you imagine running on your efforts to reform the Electoral Account Act? And of course, there's so many issues pressing for attention right now. And if this isn't buttoned up before the new Congress takes office in January of 2023, we have no real idea what the politics will be at that point and whether it will be possible to reform the act then. We're particularly keen on discussing these issues with business and community leaders because I know many of you many business leaders face pressures to take a stand now on all sorts of culturally charged, politically charged issues. But the issue of ensuring a stable, legitimate presidential election process is not one of those charged partisan cultural issues. It's nonpartisan, but it's critical for the stability of American democracy. And you all can speak very authoritatively to the importance for the economy, for investment, of an election process in the United States that continues to be free and fair and broadly accepted as legitimate. And polling shows that business leaders are among the most trusted and among the few trusted figures in our society these days. So many of our institutions no longer have that kind of trust, but on lots of polling data, business leaders, military figures are at the top of that list. So we really need, at this point, I think, support from business and community leaders on members of Congress, on senators to move this forward. And we'll talk more at the end about specific things that can be done. Let me actually now turn to some of the details of the reform effort here. Our elections now take place, unfortunately, in a sea of pervasive distrust about the institutions involved in the election process. Distrust of state legislatures, of governors, of secretaries of state, the risks of partisan manipulation from any of these quarters is now something we are much more anxious about from both sides of the political spectrum. At the same time, there's significant distrust of Congress and concerns about whether Congress might throw out votes from particular states for partisan purposes after objecting to the votes being received from that state. The task that the reform effort faces is to deal with this pervasive institutional distrust in a way that strengthens the legitimacy of the process. And in general, there are three major tasks that reform of the statute should accomplish. And as I say, there's a certain amount of consensus on at least some of these. The first is, with respect to Congress, the act should severely constrain or maybe eliminate completely Congress's ability to reject a state's votes based on Congress's disagreement with the voting process that took place in the state. When Congress meets on January 6th, it's not a national recount board. It's not a court to second guess court decisions that have been made by state and federal courts. And so this means various reforms to the act that make it much tougher for members of Congress to object. Right now, it takes only one senator and one representative to trigger an objection process for receiving the votes from a particular state. That needs to be raised to maybe 25%, 33% of Congress being needed to object before an objection becomes a valid objection that starts the debate. Maybe a supermajority requirement before any objection can actually be accepted, that is, votes from the state thrown out, and also sharply limiting the grounds on which Congress can object. And as I say, there's significant consensus in the bipartisan group of senators that we've been working with to take a number of these steps. Ned and I would probably go quite far in this direction and eliminate any role for Congress in second guessing the votes from the states based on the voting processes that took place there. But there will be movement in that direction, wherever the Congress exactly ends up. The second thing is, with respect to the states, much of this is already the case, but it's not clear. So the act has to make very clear that states have to conduct their election processes and any processes for resolving disputes about the election through laws that are enacted in advance of the election. Legislatures cannot come in after the votes have been cast and decide that they now are going to appoint electors themselves. That's already forbidden in current law, but that needs to be made more clear. The act has to also clarify which institution in state government has the power to determine the lawful winner of the election. So that if we end up in a situation in which different parts of the state government attempt to send different slates of electors, the governor sends this slate, the Secretary of State certifies a different slate. The act has to make clear in advance which of these Congress is supposed to count. And finally, there's this provision that Peter referred to called the failed election provision, which goes back to 1845. I called it a loaded weapon in the system. It gives state legislatures the power to appoint electors if the election has failed, that's the term in the statute, in their state. The provision was there to deal with a potential natural disaster or something like that that precluded voting in the state. But it's not specified in the law currently what a failed election is. And we now face a risk that legislatures are going to claim if there's something they don't like about the voting process, if the courts are taking a long time to resolve the outcome, that the election has somehow failed. That's a very dangerous provision. And so Congress, as part of reforming the statutes that regulate the presidential election process, needs to close that loophole and make it clear the very, very limited circumstances, such as a natural disaster, in which the state legislatures might be able to appoint electors if no election is actually possible on election day. The third thing, which is the most difficult issue here in the reform process, is there needs to be an additional role for federal courts laid out in the statute, a role that's very limited, very minimal, but is there to ensure the last stages of the process, that if we face the situation of, let's say, recalcitrant governors who refuse to send to Congress the slate of electors that have been appointed in that state, a scenario we now worry about, that there's a recourse for that in the federal courts. So removing Congress from the role of second guessing the state processes, making clear that the state has to function according to law established in advance of the election, making clear which part of state government has the final lawful authority, and a backstop role or an insurance role for federal courts. In our view, those are the three key elements in reforming this statute. But as Mike said, this is an incredibly urgent task right now because we cannot go into the 2024 election with all the legal uncertainties that currently surround the basic legal framework for dealing with the presidential election at the national level. So let me stop there. I'll turn it over to Ned, Ned is even more of an expert on this act than I am. So Ned, it's all yours.
Well, thanks. I don't know if that's the case, but our views are definitely in alignment in terms of the urgency and what needs to be done. So if I could just pick up kind of on where Rick left off, I'm happy to go into some of the details that Rick mentioned about the fixes that need to be done, but I think Rick laid them out pretty well. And instead, I think, at least let me start out by underscoring the urgency of the moment and therefore potentially the role that all of you can play to kind of impress upon Congress the essential need to do this now. And in order to make that point, I'd like to go back into history. Again, the statute that needs to be fixed is this 1887 statute called the Electoral Account Act. And it was enacted in 1887 in the wake of the disputed election of 1876. So that was a decade earlier. It took Congress 10 years to adopt a legislative remedy, despite the urgency that was recognized then. That was very risky for reasons that I'll explain, and we don't want to roll the dice again in the same way, and that's why we have to fix this statute now and not wait till after 2024. So kind of to set the stage for this point, many historians and political scientists, election law scholars think that we are living right now in a period of intense political polarization, not unlike the so-called Gilded Age of the 19th century in the aftermath of Reconstruction. That was a period also of intense polarization, and the disputed election of 1876 and the political conditions at the time resemble, unfortunately, what we're living through now. Most of us, grew up in the middle of the 20th century, blessed with low polarization, kind of a period of American history in terms of political contestation that was anomalous relative to the kind of contestation that we now have again. And it's dangerous to go back to those 19th century conditions. The thing that I am worried about, all of you all remember your SAT analogies, this is to that, like so and such is to such and such. I'm really worried that the relationship of 1872 to 1876 is analogous to what we just went through last time with 2020 and what we could face in 2024. What do I mean by that? Peter already talked a little bit about 1872, Horace Greeley died, but there were other disputes that were going on then because as Reconstruction was ending, there was huge political contestation in some of the southern states like Arkansas and Louisiana, to the point where Congress disqualified electoral votes from those two states. It didn't really matter because Ulysses Grant won a landslide, but that election in and of itself showed the ambiguities and flaws in the constitutional structure for counting electoral votes. The 12th Amendment, which is the relevant constitutional law, is very vague and ambiguous. It just says states will send electoral votes to the president of the Senate and they shall be counted using the passive voice that my 6th grade English teacher said never to use if you want to be clear, but our Constitution does that. And so any clarity has to be supplied by statute. Congress, and this is to the point about the urgency of the situation and the difficulty of the congressional hurdle and why it's so important to get Congress to act. Congress debated between 1872 and 1876 on what a statutory reform should look like. I mean, they knew the need for it, and they didn't just ignore it, but given bicameralism, given polarization, they could not get a statutory fix across the finish line before the major disputed election of 1876. And that was, you know, our minds are seared by the violence in the Capitol of our January 6th, 2021, that was awful. But from a governance point of view and a constitutional stability point of view, our experience was actually less dangerous than what happened in 1876. And this is why Peter's slides are so important and so relevant. I'm not going to go into all the details of just how precarious the fight between Hayes and Tilden over the 1876 election was, except to say that it was the members of Congress that drew their pistols when they were counting electoral votes. And the Speaker of the House had to call the sergeant in arms out against members of Congress, not just people who were, citizens who were protesting. And we almost had a second civil war over the outcome of the election. Again, we could discuss it in Q&A, how it got resolved. But after the crisis of 1876, having failed to adopt the statute ahead of time, Congress said, well, we've got to have the statute. It's really apparent we can never go through this again. And yet they went through 1880 again without a statute. They went through 1884 again. And it was only when they were coming up against the 1888 election that they said, we cannot roll the dice again. And 1880 and 1884 were quite close. Fortunately, it didn't spin out of control. But every time you go into a presidential election without a good statute, you are risking huge constitutional calamity. And so that's the kind of risk that we are facing now if we don't repair the statute. The other point that's useful, I think, from a historical perspective, why do we have such a bad statute at the moment that needs the kind of repairs that Rick was talking about? It's because when they finally got around to adopting the 1887 statute, that was the best that they could do. They knew it was ambiguous. They knew it was not perfect. A political scientist at that time said it was gobbledygook and he didn't understand it. Kind of true, but they thought, well, something is better than nothing. And maybe that is true, but they were hoping that some future Congress before the next emergency occurred would provide the kind of clarity that Rick is talking about, so that they wouldn't leave these holes and these ambiguities that we are confronted with. So as awful as our January 6th was, in 2021, it showed again the urgency of this. It showed, as bad as what happened then, it didn't, there was, for reasons we can discuss, there was never really any doubt that Joe Biden was going to get inaugurated because he had the votes in the Senate and in the House. So as long as they could meet after the rioters were cleared from the Capitol, the outcome was clear. What's much more dangerous, as Peter was talking about, is when, because of contestation in Congress itself over disputes that come from the states, there's ambiguity, uncertainty about what Congress itself will do. That could lead to stalemate between the Senate and the House, and the kind of constitutional crisis that we averted. As Peter alluded to, the most dangerous situation is when the two parties are fighting over the outcome of the election on January 6th. Both candidates are claiming victory, and both sides think they should win, and they have a way to win before Inauguration Day 2 weeks later. And the way that conflict can be set up because of our institutions is that when you've got a president of the Senate of one party and a Speaker of the House of the other party. You could have these two leaders in the, because the Vice President of the United States is the Senate President, and that's a legislative role. You basically got the Senate President at loggerheads with the Speaker of the House. That's very dangerous. I mean, it's one thing for Congress to be deadlocked and failing to pass a law that we think we need, like an environmental law or whatever. We need a president 2 weeks later by January 20th. So when you've got a stalemate in Congress over that outcome, you have a serious crisis. And the way in which that could happen, given ambiguity, is the Senate president could be claiming she sees an interpretation of the rules that lead to one answer, namely, as Peter said, a re-election of Biden and herself, if she's still on the ticket, and declaration that the Democrats have won. But if Speaker McCarthy in the House is saying, no, 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 we see it differently, we don't want to count those votes, that's where you could have, genuine crisis. And as Larry Diamond, who you're going to hear from in a minute, and I wrote in advance, it can get so dangerous, like the Joint Chiefs of Staff don't know who to give the nuclear codes on January 20th. It's that problematic. So that's why the best thing that we can do is fix the ambiguities like Rick talked about, provide maximum clarity in the statute so that everybody knows what the answer is. Of course, politicians are going to grumble if they don't like the answer, but at least if the answer is clear, they can't exploit ambiguity. So let me stop there and turn it over to Larry.
Well, thank you, Ned. Thank you, Rick. Thanks all of you, Michael, Peter, Herb, for arranging this. Time is kind of crept along here, and there are a lot of questions, so I'm just going to make a few very brief points. The first one is that if you're not frightened by what you've heard, you should be. If you looked at Peter's slides and said, oh, that's from a science fiction movie, fortunately, we live in the real world where that can't happen. The fantasy is on your end of thinking that it can't happen. I, as a lifetime scholar of democracy, I'm not a legal scholar, I'm a political scientist, but it's been my privilege to work with Rick and Ned. Believe there is a very serious chance that we will suffer a breakdown of American democracy around the presidential electoral process in 2024. And if it happens, if we cannot clearly determine who the winner was with some kind of legally recognized legitimacy, even if we still have one party or the other denying the legitimacy, the levels of violence, I think, will exceed what Peter was envisioning, and the damage to the American economy could well be what Peter was envisioning. The existential self-interest of American business in doing what can be done statutorily to construct better guardrails and better clarity around this process is, to me, overwhelming, simply overwhelming. Business often asks itself, what are the risks on the horizon and how can we guard against them? Usually, this risk reduction involves business strategies that are largely, unique to the corporation. But in this case, I think there is something that American business can do and really must do to ensure that some of those extremely rickety and virtually non-existent by now guardrails around our electoral process can be at least somewhat fortified. Fixing, amending the Electoral Account Act and the Failed Election Act, hopefully as well, is not going to solve every problem and vulnerability. But, you know, we have a moral and political obligation to ourselves and to our country to do what can be done. And I think that there is, in these coming months, Ned and Rick are closer to the process, so they can comment on it. There's a window of opportunity, and it feels like we're somewhat close. And it would just be tragic. It'd be a tragedy if we lost this moment. And, you know, if the worst comes to pass and we do lose this moment, I think history will damn every one of us who heard the preceding 3 presentations or things like it that have been written and talked about and didn't do what we can to bring this about. I'd like to just make one other point, which Ned and Rick can react to if they want. I think our best hope is going to be to construct these guardrails and remove these loaded guns through statutory reform, and then hope as much as possible that the courts, the federal and state courts, will be, you know, the arbiters of any disputes. And I think it should be obvious that we may need to give that judicial process more time than it now has, given the date on which certification of a state's electoral votes under the current, quote, safe harbor provisions needs to occur. I personally hope, I don't know where this stands, Rick and Ned could comment on it, that the reform of the Electoral Account Act will also move the safe harbor date back. I believe it was December 8th in 2020. Is that right, Rick and Ned? And it'll be a similar date probably in 2024. Move it back about 3 weeks or something. It doesn't sound like a huge amount of time, but it might give more time for disputes around state election results to be resolved in the courts so that they don't contaminate the national process. But you do what you can at any moment in time to try and reduce risk, and anything that can be agreed upon in the amending of these acts is going to be much better than nothing at all. And I hope members, reasonable members of Congress of both parties, will recognize that.
Wow. Well, this is more than food for thought. And I think many of us have been looking at the chat boxes and realizing that there are people who are responding to Larry's call for this, not letting this real risk become a fact. We don't need to look back or look forward to that kind of a historical moment. I think people are asking what is already in place. Perhaps one of you, I know Rick and Ned, who've been talking to the bipartisan group, can perhaps put some bones on, or excuse me, some meat on the bones as to who's involved, who needs to be brought into it to make it work, and how we avoid the potential derailment by some of the leadership in either the House or the Senate.
Not my
Whoever's
dog.
got the dog barking should please mute their phone.
Dog bark.
First, in response to some of the questions in the chat, I think the process is going to be driven through the Senate. There is a committee in the House that's doing very, very good work on this as well. But everyone understands with the filibuster, the need to have broader consensus to get anything through the Senate. And so I think that's the most important place to focus. Second, I think it's important at this stage not to get attached to any particular bill that's been introduced, not introduced because they've actually refrained from formally introducing a bill yet. There are a couple of drafts that have been generated. In particular, the committee that King, Klobuchar, and Durbin are on have actually released a draft. Now that's a Democratic draft, and that's not from the bipartisan group of senators yet. The bipartisan group of senators are working on putting together a draft, and then these two drafts will have to be knitted together ultimately in the Senate. But I think it's important to focus on the big principles and the urgency of getting something done, and not get locked into one version or another version, especially at this stage of the process. There is significant interest that across the aisle, people should have in this issue. So I see in some of the chats, people are concerned. Would Ted Cruz in Texas be someone who would be engaged on this? Maybe not, but there's another senator from Texas, John Cornyn, and he certainly understands these issues. He was a former judge. And so I think what's important is that members of Congress hear from constituents and from leaders that about the urgency of this issue, that the pressure just has to be kept on the issue. There is reason to believe something will happen ultimately. McConnell has said he understands that there's some serious issues that need to be looked at here. He's authorized the Republicans to negotiate, the same for Senator Schumer, who had been reluctant for a long time to authorize Democrats to participate in the process until the voting bills that they were more interested in definitively died off. And now the floor is open for this issue. But as I said, this is not the kind of issue where there's a lot of interest group lobbying and pressures. So it's really important to mobilize people with respect and authority in these states who have contacts and know these people and can press upon them the importance of addressing this issue.
And if I can jump in, it's important that both parties in the Senate be on board with the philosophy that Rick outlined. In the chat, I'm seeing a lot of discussion, appropriately so, about the Trump wing of the Republican Party perhaps not wanting reform. Leader McConnell has, he keeps quiet, but he's allowing the process to go forward, the bipartisan process that Rick is talking about. And there's some reason to be concerned that the Democrats in the Senate may be skittish of the kind of bipartisan set of principles that Rick has adopted. So it's important that both sides come together around the notion that, as Rick said, that the election be decided according to the rule of law, not according to political gamesmanship in anywhere in the states or in Congress. And so the way to have the rule of law settle who won the electoral votes of each state is to have a good bill come through Congress that sets the parameters, including the federal court provision that Rick talked about. And that's the best way to avoid the kind of violence that we're concerned about is to have clear, say, presidential elections are decided according to the rule of law, and to get agreement on that point. And I think both parties need to embrace that ahead of time.
I should point out, because there's a sense of, the pessimism in some of the questions about whether anything will ultimately happen. Keep in mind, from the Republican side of the aisle, they're concerned about Democratic governors in some of these states who they believe or fear will conclude that there's something about the voting laws constitutes vote suppression, and that the outcome is not legitimate. It was a close vote. But if this law hadn't been passed or that law hadn't been passed, the Democratic candidate would have won. Vice President Harris will be presiding over the joint session, not Mike Pence. And so there are just politically self-interested reasons that can also motivate Republicans on these issues. So it's something that both parties, I think, will come to see as in their self-interest because of their fear of what the other side might do.
Yes, and that's why it has to happen now before the midterms, because the role that governors play under the current flawed statute means that each party can kind of better get a sense of what its strategic advantage might be if they know who has which governorships. If they don't know who's governor of Pennsylvania, Michigan, Wisconsin, and so forth, as Rick said, you can paint scenarios where it's in the Republican advantage to want to lock in a rule of law answer ahead of time.
Let me answer. There are
Mike.
several questions in the chat about what we can do about it, and we do have, in fact, a list of talking points that was put together by staff on Leadership Now project, which I could be happy to circulate to the entire group that's on the call today. But the key is not just to write a letter or to sign a petition. Most of the people on this call, if they think about it, either know somebody who's a senator or a congressman, or know somebody who knows somebody or knows one of the senators. And we need to put the pressure on more directly. It's too easy to just, count up letters or votes and nobody pays too much attention to them. But people who can get the attention of the Congress, that's what we need to get to. And I'll be happy to circulate the talking points, but the key is to get them to the people who can reach the senators and congressmen that matter. I don't know if Rick and Ned, in your dealings with the Congress, are there some people who are on the fence that we can suggest are particularly important to target in terms of bringing it to their attention? I have one other question that's part of that, which is, what about the media? Is there some value to bringing this to the attention of the media, getting on some talk shows? I know you all have connections with some of the various networks and groups on both sides of the aisle that I think are worth at least understanding the problem as we laid it out today.
Yeah, as you can imagine, this is not the best issue for ratings. We've written op-eds in the Washington Post, the New York Times, and other publications, and occasionally they will run a story in the cable networks on this issue. And as things heat up, hopefully they'll do more. But they're technical issues. They're hard to understand, and it's not an easy sell from that perspective. And that's why the concern is, the members of Congress and the Senate, even though many want to do something on this, are just not going to find it a high enough priority, given the dynamics around attention seeking and what we all know to be true. So that's why the pressure has to be brought to bear through whatever routes one can marshal it.
Someone's asked who is on the Senate committee. Can you just go through? I know there's about a little over a dozen people not on the committee, but in the group. You mentioned already the Senate committee that officially has responsibility, but the bipartisan group is perhaps more critical.
So the bipartisan group was put together by Susan Collins and Joe Manchin. I'm not going to remember all the people who are part of it. And some people are more centrally engaged than others, but that's a good starting point. I remember Senator Tillis from North Carolina is involved, Senator Murphy from Connecticut. Ned, do you remember some of the other bipartisan group?
Boy, there's up to a dozen names, and and I'm not sure I've got all of them on the top of my head. I mean, I think you made the key point. I think the relationship between the bipartisan group and the Rules Committee is essential. My guess is that, as you said, the bipartisan group will come up with something. And it's more important to embrace whatever they come up with, as long as it has clarity, than we agree with every detail on it. Because getting something passed is better than not getting something passed. And what I'm a little bit worried about is that there's going to be slippage between the bipartisan group and the Rules Committee, because I think the Rules Committee is less collegial than this ad hoc bipartisan group. So, if we can get Klobuchar and Blunt to do rules in a bipartisan way, that would be great. But that's the part that I'm more worried about.
Okay, I think part of the challenge is going to be to the people who are assembled here to try to use their imaginations and their entrepreneurial spirit to come up with ways to get to Congress to make this a priority, and to recognize the urgency of it, to recognize that the risks are real and not a fantasy, and that we actually must find ways to force action on something which is understandable to well-educated people, but is not going to raise the visibility of the voters. But focusing on Congress is a smaller group of people who are willing to understand the issue if it's brought to them by people who they trust. And I'm sure there's some of those people on this call today.
Mike, I just want to make one comment going back to some of the questions in the chat box about Republicans versus Democrats and whether this is a partisan issue. When I sat down to write my piece of the presentation, I came up with 4 or 5 alternatives. Some of the alternatives had the Democrats stealing the election. Some of the alternatives had the Republicans stealing the election. Going back to something Ned said, tell me who's going to be elected the next governor of Pennsylvania, the next governor of Michigan, the next governor of Arizona, and I can give you all sorts of other alternatives. The fact of the matter is that these laws threaten both parties equally. This is an equal opportunity shit show, excuse my French. And, and it's something that we really have to pay attention to now. I actually, before the last election, I followed something that Ned had written, and I gave these series of presentations that showed riots and deaths. I said there are going to be riots and deaths after the 2020 election. And when I gave all those presentations, people laughed. Okay, you're trying to prove a point. I wasn't trying to prove a point. I read what Ned had to say, and I believed there were going to be riots and deaths after the 2020 election. And I believe that there is a real possibility that we could look at 2024 and you could see the stock market cut in half, and you could see somebody have civil war in city streets, and it could be a real disaster unless we wake up and address some of these issues. This is about the rule of law.
And one point about how the process might get derailed in Congress, the Democrats in good faith have wanted to do other electoral reform. You may have followed all the news over the various voting bills that couldn't break through the filibuster last year. And from what Rick and I have heard is that there is some desire on the part of the Democratic side to tack on as much of what they couldn't get passed last year to Electoral Account Act reform. Of course, the Republicans oppose that. And I think it's the view, it's certainly my view and Rick's view, I think it's Larry's view as well, is that whatever you thought about last year's fight, this one issue is so important, it needs to be done. And so I think part of it's necessary to remind or convince some of these senators is, put aside last year's fight, just whatever else, focus on this one thing, even if you can't do anything else, doing this is essential. And one of the reasons, as Rick said, why Democrats are afraid of doing this is they're afraid that if the Electoral Account Act reform locks Congress in and is not a national recount board, like Rick said, I've heard Senator Schumer say this, they're afraid that that's going to tie Congress's hands and force Congress to ratify, if you will, manipulation that has occurred in the states by the legislatures and the governors in the scenarios that Peter has talked about.
And again, yeah, go ahead.
Just to finish, but the principles that Rick laid out avoid that, because if you get that federal court piece that he's talking about, you
We're gonna go
can't
to 42nd Street and 10th Avenue.
you can't have manipulation by a rogue governor or a rogue legislature. The courts will constrain the states to what the true answer is in the states, and then you'll have Congress constrained to accept that true answer, and you can't have rogue members of Congress from either party trying to undo the result. So part of the persuasion effort, if you will, is convincing Democrats in Congress to trust this reform and not to think that they need the power to override what the states do. Because if Democrats veto this reform, if you will, it's very, very dangerous. But I think there's some risk that Senator Schumer may be an obstacle to reform for that reason.
Yeah, I have to go now. I actually had to go 10, 11 minutes ago, but I just want to echo what Ned said and reiterate what I said, that the judiciary remains the best hope for resolving electoral disputes. And even if you're a very partisan Democrat, the idea that electoral manipulation, just as a practical matter, the idea that it could somehow be reversed in the Congress in the near term, it's just not a politically smart scenario, because Democrats are not going to be in a position the way it's looking to be able to carry the day in the Congress. So even from a practical standpoint, the courts are the best hope. And at some point, we have to stop thinking about political calculations and start thinking as Americans again. Thank you all.
Thank you, Larry. Thank you, Ned.
Sorry,
And
I
I
have to go.
know Rick also had to jump off the call, and I appreciate your hanging in as long as we did. I also appreciate the audience staying with us. We had well over 100 people still at the end of an hour, which is, I think, a sign of how seriously people do take this problem. So I hope we can come back and give you more information to make it easier for you to reach out to your Congress people in a way to get them to take it seriously in the next month or two, because timing really is critical on this, and we're running into the end of the road on this. So please do continue the momentum. Thanks, everyone. Any final comments from others?